Hello everybody, you have tuned in to Eric Jose on Making a Murderer on YouTube. I cover virtually any aspect of making a murderer. I go over the evidence, the documents, the photos. So if you like, stay tuned, and in the future I'll have many more videos besides the one you're about to see. Hello folks, we are back today with segment 3 of reviewing the Banc review for Brendan Dassey and his writ of habeas corpus. So, we are now going to start today with one more thing about Luke Berg. As you know, the first 2 segments were kind of about Luke Berg. One more thing about Luke Berg, and then we're going to move into Miss Nyrider and some of her interactions with the judges there. Today, we're going to see Laura really having to answer the judges who don't necessarily agree that Brendan should be getting his habeas relief. And so she's going to face some pretty hard questioning by those judges in these next few segments, this one and the next one. I would just encourage everybody to understand that these judges aren't just frivolously deciding. You know, there's reasons why they see things the way they do. And I just encourage everybody to remember to just... My favorite hashtag is to hashtag be classy for Brendan Dassey. And that really means... not to harass the judges or the people for the state that are involved in this case. That to just let that stuff go. Keep your interest in the case. Keep watching what's going on. Just keep an awareness of everything, but to not really directly contact those parties involved. Like the judges or the lawyers for the state and that sort of stuff.
So you may proceed.
Good morning, and may it please the court. Brendan Dassey confessed because his guilt became unbearable. What he and Avery did to Teresa was horrific. And
what happened to Teresa was certainly horrific, but isn't the issue before it? Well, there are 2 issues before us, as I take it. One is whether the confession that you have put together from the various things that Dassey said was, from a constitutional point of view, voluntary, or to put it more accurately, whether the state court determination that it was voluntary was a reasonable assessment. And secondly, the effectiveness of counsel that he received from Mr. Kaczynski, who was representing the victim's family, it seems. So no one questions the terrible nature of this murder. How could you? But whether Mr. Dassey was responsible for it or whether he just went after the fire was lit is a serious question.
Absolutely. The investigators just nudged the confession out of Dassey.
They took nudge, really?
Now, it's not necessarily my intent here to pick on Mr. Berg. Having said that, Mr. Berg makes it easy. In my opinion, Mr. Berg made some mistakes. He made some statements that I really think he shouldn't have made. Well, in the sense that he was arguing his case, the things that he brought up I just felt weren't helpful to his case. I mean, he just doesn't, he just left it out there for us. And this is one of them. That thing you just heard. I mean, just like Kratz, just like Vogel did at Stephen's original trial, invoking those emotions and feelings and trying to bring that into a courtroom. And, Chief Judge Wood, you can tell she wasn't having it. Maybe that she's already been pretty well versed in the history of this case and this family. And she pretty much nipped that in the bud right away. She wasn't going to have any of that emotional sway in her courtroom or in that courtroom because they were there to decide this in a fair manner. And she makes that very clear to him right off the bat. And I really thought that was great. Now we're going to move into what I feel is Miss Nyrider's proud moment here. She really takes the questions that she gets from the judges here. She takes the criticism that she gets from Judge Sykes, who is clearly on the side of the state. And she comes back and she makes her point, and she makes it well. She brings it together very well. I love the way she did this. And so I'm going to play this little clip here. It's a bit long, but I'm going to play the whole thing, and we're going to come back and talk about it.
To quote Miller, would you say that the police here used tactics, quote, so offensive to a civilized system of justice that they must be condemned under the Due Process Clause of the 14th Amendment?
I would, Your Honor.
And what are those?
Those tactics include issuing a promise of leniency to Brendan Dassey.
There was no promise of leniency.
Not
There
when
were vague
judged,
assurances at best.
not when judged by the standard of an adult.
Even with an intellectually challenged 16-year-old, there were no assurances or promises. There has to be a concrete promise, fraudulent promise of leniency for it to bear on the voluntariness of the confession. Vague assurances are not enough, and certainly not under 2254D review.
There was a very specific and concrete promise of leniency made in this case. Honesty will set you free, is what they told him. Now, Your Honor, it is true, unquestionably true, that you and I would understand that to be a quote from the book of John, an idiom. But the record in this case is indisputably clear that idioms are the one thing that Brendan Dassey cannot understand. He has no choice because of his disabilities.
He understood plainly that he was being encouraged to be honest and to get it off his chest.
And that the exchange for his talking was to be set free. He had no choice but to take those words literally.
Is the key here that his IQ? If we accept the fact that he has a lower IQ, that's it? Anybody that has an IQ of that level can't be questioned the way he was?
Well, Judge Can, that's oversimplifying it just a little bit. There's more factors than just IQ.
Certainly not, Your Honor. This is long-standing federal law, and there have been many cases with many interrogations of mentally limited individuals that have come into evidence without any problem under Miller v. Fenton. This is a unique
This was
case.
not an aggressive questioning.
It is a case of psychological coercion. There was a promise
Well,
of
there's
leniency.
no right. In fact, there's case law that says they can bluff.
They can bluff, Your Honor, but they cannot so distort his rational will that he was
That's
incapable
because of his
of...
IQ?
Because of his IQ, because
So
of his
let's
age.
get back to my original question. This whole thing revolves around what his IQ is.
Because of his disabilities, Your Honor. The IQ is part of the disabilities, but in particular his impairment's undisputed record that he was unable to process idioms. Combine that statement that honesty will set you free, with
That's
the
not
assurance...
true?
I'm sorry?
That's not true?
That statement was not true, Your Honor, certainly not. And you see him believing, of course, that it will be true because you see him expecting, after confessing to rape and murder, that he's going to go back to school. And even after the officers disabuse him of that notion, they say to him, Brendan, you know we're police officers, right? And because of what you said, the law won't let us let you go. He still clings to that illusion, and he says, is it only for one day?
Even if they attempted to correct him, then it's still wrong.
Honesty will not set him free. That's correct.
Even if the police attempted to correct his misunderstanding, that doesn't do any good?
They only attempted to correct that misunderstanding after he confessed, when they finally break the promise. And my colleague on the other side for the state of Wisconsin spoke to Brendan's demeanor after the officers told him that they were going to arrest. Spoke to the fact that at that moment, the first thing he did was ask for his mother. At that moment, he began to weep. Why only then? Because that's the moment the bargain was broken for him. That's the moment he understood.
What bargain?
That honesty and repeating back the story that the officers gave him would set him free.
So there was a bargain?
There was a bargain, Your Honor. Repeat back the story that we want to hear, and in exchange you will be set free. It was a bargain that was understood as such because of Brendan Dassey's limitations, which is precisely what the Supreme Court has directed us to do, to define coercion in terms of how a reasonable person in that suspect's position would have perceived.
And that's because of his lower IQ?
And his impairments and his disabilities and his age. Yes, Your Honor.
And the fact that he is 95% more suggestible than the population.
Well, let me just say, I know that Laura Nyrider's a class act, and she probably didn't take any offense to that, but I truly felt that Judge Can was kind of displaying, like if he wasn't even listening the whole time, He had to ask 4 times about the IQ, ignoring the fact that it was IQ with the disabilities, with the suggestibility, that it was multiple factors. He kept trying to minimize it, seemingly deliberately, down to just IQ. I found that to be disrespectful to Laura, especially since he did it like 4 times. But then there was the thing about the bargain, as if he's not been listening to what she's been saying up to that point. That Brendan perceived the truth shall set you free as a bargain with him and the officers, and how she's explaining exactly how he perceived that bargain and how his actions show that he really perceived that bargain as such. Because he, number one, thought he was going to be going back to school. Then when he finds out he's not doing that, he's asking if it was only for 1 day. She makes it very clear. And it just seems like he's being a little disrespectful of her right there. And I find that a little disappointing. But I think Laura really did well there. She really stuck in there, held her ground, didn't get shook up. And she really, really brought her point home and nailed it, in my opinion. So we're going to go ahead and move on to the next bit now, which is going to be about Hamilton. And he's got a question for Miss Nyrider here.
So, Ms. Nyrider, the police need to take account of all circumstances, right? The police rarely will have access to a full psychological background, school records, and all the information that's been used to challenge the voluntariness of this confession. They simply deal with the first witness and then later suspect that they're dealing with without all that background information. If we were to affirm the grant of habeas relief in this case, which you've described as unique, what practical advice would you give to police about what is and is not permissible in interrogating a high school boy who's not very quick?
I would say, Your Honor, that taking this case as an example, these interrogators knew at the least that he was 16 years old. Based on their interactions on February 27th, they also had at least some reason to believe he might be limited. He wasn't able to spell agent or detective
So
on
what should
February
they do?
27th.
So what should they do? What can they
give him
do
back.
to solve the crime?
They may still question him. There's no doubt about that. But
Can they
can't
bluff?
say things. They may, as long as it doesn't overbear his will. But they cannot say things that will land on this defendant as a promise. They should never say things like, I'm a cop, but I'm not right now. I'm a parent, when you've got a 16-year-old in the interrogation room. They shouldn't say things like, we know you're scared of arrest, but you've got nothing to worry about. Everything will be all right.
You're creating new law now. There is no case that says that, and we're here on 2254D review. A federal court cannot create new law on habeas review, and that's what you're asking for in this case. It's just flatly impermissible under all the Supreme Court's precedents.
Your Honor, I am not asking for the creation of new law. I'm asking for this court to apply decades-old law.
You're identifying criteria and things that the cops cannot do. There is no case that says they cannot do those things.
I am not asking this
You're
court
asking us to use this case to establish that new benchmark for investigators in interrogating juveniles. There is no case law to support that. Under established law under 2254D, you must lose.
Let me be very, very clear. I am not asking for this court to erect a rule that anything the officers said will always be proscribed for going forward.
Aren't you focusing, that's why I want to come back to 2254D too, because that's a very factually bound circumstance, and it's the decision based on all of the evidence that with this package of facts, the finding that this was a voluntary confession was not even a possible finding on this record.
Okay, so here's where I feel like Laura Nyrider gets kind of disrespected again, and possibly maybe either the judges don't understand her argument or they're just not paying attention to her argument. It's hard to say at this point, but it seems like she's getting kind of disrespected by Sykes there. But it starts out with Hamilton saying, okay, in this hypothetical situation, let's say we grant habeas relief in this situation, which you say is unique and all that, and we grant habeas relief in this situation, what, moving forward from the future, do you suggest or do you think would be proper going forward in the future with cases like this if we were to grant the habeas relief? So it's this hypothetical question, and he's asking her to give hypothetical or to give suggestions as to what officers might do in the future in a situation with this, with a very young, very suggestible suspect in the future, to avoid this mess, essentially. And that's what he's asking her. And so she begins to answer the question, well, they should probably not do things like this and not things like this, and they shouldn't say things like this, And at that point, Sykes takes it as that's the argument that Laura was making. The problem was that Laura was just answering a hypothetical question and not making an argument. And it takes Laura a while to get steered off of that subject again and back onto what she was talking about, which was the fact that the suggestibility makes that idiom a promise to Brendan.
So another case could come along when somebody would say, "You shall know the truth, and the truth shall make you free," and that would not be a promise of lenience.
I would imagine for most people that would not be a promise of leniency. That's correct. Mm-hmm. Exactly right.
So there's no automatic character to the rule if it's a D2 problem. Was this a promise or was this not a promise?
There is no automatic character. We must not evaluate these tactics in isolation. The Supreme Court directs us to do otherwise. They must be evaluated in conjunction with the package of Brendan Dassey's vulnerabilities. The Supreme Court here has instructed us to consider Brendan Dassey's reaction to this promise in part as a part of the consideration here when it directed us in Yarborough versus Alvarado to turn to the actual mindset of the suspect. That's why the moment when Brendan Dassey asks to go back to school is so powerful. It speaks to his understanding of the bargain that has been struck.
Now, this is a point that I've been kind of harping on a little bit ever since Brad Schimmel said he was filing for on-bank review. He tried to claim as if this was going to completely change the way that all interrogations happen in that area and in the Seventh Circuit. No, it's really not. It's really only going to affect a very, very tiny, minute number of cases that have a suspect like Brendan, who is highly suggestible and not the quickest of mind, and officers who basically make these consistent reassurances and use an idiom with somebody so suggestible. That's how specific this is. And so Brad Schimmel's claims that this was just going to change everything across the board have always been kind of ridiculous to me. And that's what they're addressing there. And Laura Nyrider is saying, no, most people, this wouldn't apply to most people. And because that's exactly right. If any of us got in trouble or whatever for something, and we tried to go to habeas court and we were trying to use Brendan's case law to apply to us, it would not work. We would fail because it wouldn't apply to us. You have to have similar circumstances. So only in the future, only cases that we'll be able to look to Brendan are cases that have similar aspects, a similar suspect, similar interrogation tactics, that sort of stuff. And we see Nyrider ending up there just talking about the fact that Brendan clearly perceived that bargain and it was clearly there. So that's about it for this video, folks. If you haven't already, please hit subscribe and we'll see you later.